concept of extinguishment of Aboriginal title is a very sensitive issue. And if
Yes.
a court were to find Aboriginal title extinguished in favor of private property owners, presumably there would be a live question about compensation to the Indigenous community, and perhaps vice versa. If the court said private property is going to be adversely affected, what remedies do those people have, having bought land thinking that the government said, here's good title? I looked in the land title, it says it's good. So the government chose not to argue those points because these directives promise not to. And, the Premier was the Attorney General when those were written. The Premier was the Attorney General for the first 3 of the 4 years of this trial. And, I think it's very important to understand that on this key issue, the court expressly noted the two governments didn't even argue it. The city of Richmond was left to argue this. And imagine you're the court and the city of Richmond saying, well, title was extinguished by the province. And then you look over at the province, we don't know, that's not our position. Puts a court in a very difficult spot, I think.
A massive story took place in British Columbia. I guess it was just last week. Feels like a little longer simply because there's been so much going on, plus variations of this theme over the last year. I'm talking about the Aboriginal title. It was Cowichan Tribes versus Canada, the Attorney General. But the bottom line is this, is talking about Aboriginal title can supersede fee simple, that's how we own our homes mostly, land ownership. There's so much to this, but that's what grabbed people's attention. I can't do it justice, but luckily I've got Robin Junger with me. He is the former Chief Provincial Treaty Negotiator in British Columbia. He is also a lawyer with Macmillan LLP. Robin, appreciate you finding time for us again.
You're most welcome.
Did you think you're going to be back talking to me about this soon? After last year, we felt like we went through a similar thing. I guess the foundation is same, but maybe you could sum up the case, easy for me to say, nearly 1,000 pages, and 4 and 6 years out there. But can you sum it up for just the audience?
Sure, and yes, I'm not surprised to be talking about this again. There's a lot of this stuff swirling out there, not just this decision, although it's getting a lot of headlines. The decision is massive. On the Canley website, it lists it as 979 pages. There was 80-some lawyers involved. The trial occurred over 4 years. It's very difficult to do it justice in a summary, but basically what it boils down to is the Cowichan tribes, asserting that they had Aboriginal title, a village and a related control over a portion of Lulu Island and the related fishing area prior to the assertion of sovereignty, which was 1846 in British Columbia, the Oregon Boundary Treaty. And so they're relying on the law of Aboriginal title to say we have established Aboriginal title to that area, and some of those parcels are owned in what the law calls fee simple. It's a technical term, but it's basically private property. There's like any of your listeners that have a property title, it's in the land title system. That's what fee simple means. And so the court found that they had established the test for Aboriginal title. It's based on occupancy and control, and it goes through an enormous amount of evidence there. And then it talks about the relationship between Aboriginal title and private property ownership, which is obviously very important to many people. And this is where I think the court made findings that have established, got some headlines. It referred to the fee simple title being deficient and invalid, or defective and invalid. And it also made some findings and statements that Aboriginal title and fee simple can be on the same land at the same time. And that's a very challenging proposition because, fee simple is the right to own your land, to use it, to get the benefits from it. And Aboriginal title is the right to the possession of the land and the right to the benefits from the land. The courts have expressly called it akin to fee simple ownership. The only difference is Aboriginal communities are not allowed to alienate it. They cannot sell off Aboriginal title lands. They can't destroy it. Not that they would, but those are the limitations. So fee simple title and Aboriginal title, quite simple in similar in many respects. And this is the first case where the court had to grapple with the relationship between Aboriginal title and private land. In the two other cases in British Columbia where the courts have found Aboriginal title to exist on the facts, the First Nations did not. In the Chilcotin case, 2014, the First Nations specifically said, "Look, we're not looking for title on private land, and we're going to avoid that thorny issue. Please don't give us anything or declaration in relation to that. That'll be dealt with, another day." And in the recent New Chatlitz decision a year or two ago, I don't even know if there's any private land there. There certainly wasn't any declarations in relation to the private land. So this is the issue. There's some fishing rights as well. There's a million different issues, but that's the core issue here. Does fee simple really mean you own your land if it's also the subject of Aboriginal title? And to be clear, pretty much the entire province is claimed as Aboriginal title. Most of it has not been litigated yet. Some in the Chilcotin, some on the west coast of Vancouver Island, and now this chunk of Lulu Island. And so I think it raises very profound questions. There are some aspects of the findings in the decision that are unique to these 4 or whatever the number of parcels are, the fee simple parcels on Lulu Island. And I think it's maybe more than 4, but in any case, it includes some federal land, some City of Richmond land, and potentially some private land, or it does include, I think, some other third-party owned private land homes. And one of the things that the court found, there was various bases for this, including the promises that were made on these lands in the 1800s and not being lived up to, etc. But there was at least one aspect of the decision that wasn't limited to these lands. It was whether, when BC joined Confederation, the terms of union effectively carried forward the Aboriginal title, because BC took the lands with subject to these interests. And so I read that aspect of the decision as not limited to these particular parcels of land. I think many other people agree with me on that. And so this case raises the fundamental question about, you think you own your land? Well, do you, if it's claimed Aboriginal title? It hasn't been litigated yet, but what about when it is? And in this particular case, at the end of the day, the court did not issue declarations to any of the land except that owned by Richmond and the federal government. They didn't actually issue a declaration specific to that. But that's kind of cold comfort to most people, because that's kind of a technicality. The underlying reasoning has cast this major cloud on those other homes and anybody, I think, who owns private land in BC. So that's a lengthy, but I think, hopefully succinct summary.
And the most straightforward conclusion is the uncertainty this has created. I'm thinking the economic uncertainty, obviously the personal financial situations of some homeowners. If I'm thinking of buying, do I have to, literally say I'm not going to do that in British Columbia or certain parts of British Columbia? I would think also, though, the implications are further afield. I mean, I know that there's other sort of, let's call it, similar cases. I mean, I think I should buy the province of New Brunswick. I mean, it seems to have issues. So I'm just wondering, does it set a precedent? Does it at least suggest that it could, as you say, beyond the whole British Columbia boundaries?
Well, that's where I, depart a little bit from perhaps some others. I think that this case, of course, the Attorney General said it's going to be appealed. Over the weekend, the Attorney General reviewed and the staff reviewed the decision over the weekend. I did the calculations. If you read 3 pages a minute, it would have taken 47 hours of reading to go through it.
Mm-hmm.
It's remarkable that appeal was announced over a weekend. And I think they understand what's at stake. They certainly understand, I'm sure, the public concern about the case. I think it's very likely to go to the Supreme Court of Canada. I think it's unlikely that the BC Court of Appeal or Supreme Court of Canada is going to ultimately issue a decision that is going to upend the entire, legal order. So I think, in that respect, we should give the process some time, let it play itself out, and not get too exercised. Mm-hmm. But at the same time, it is what it is. And unless and until overturned on appeal, it is the law of British Columbia and could potentially influence other provinces as well.
Well, and it's interesting to hear you say that they've announced they're going to appeal the decision, the NDP government in British Columbia, but it doesn't seem they seem to have done many things that would suggest they're in support of the general thought of this or the general push of this? Because aren't they making some? I mean, I've been reading a couple of side deal isn't a good way to play it, but not out in the public. Public's not aware of similar deals about granting First Nations, full right and use, and not, public consultation.
Well, there's all kinds of things going on in the province right now, and two of them are directly relevant to this
Mm-hmm.
case. First of all, as I said, one of the real questions in this case is, can Aboriginal title and fee simple exist at the same time? I don't think they can. I've said that publicly. I'm not the only one to say that. Other lawyers will argue the other side, but it's certainly a live issue. And the court actually noted in its decision that what it's finding here is consistent with what the BC government has done in the
Yeah.
Haida Rising Tides Agreement and the Haida Nation Recognition Act. It has acknowledged Aboriginal title over private land and legislated that. Now, I
Yes.
raised
Yeah.
concerns about that at the time. I think there are real problems with that concept. There is a provision in the agreement and resulting legislation that says private property is respected, will be respected. But I just don't understand how the two can fit together. And B, even if they can, you now have the Haida Nation Council having the ability to set all kinds of rules, presumably, on the basis of Aboriginal title that may not take away the fee simple, but can restrict use, perhaps restrictions on alienability, who you can sell it to and when, and all that sort of stuff. So it's a real issue. So the BC government, did that in 2024, and the court noted that. And similarly, in this case, there's a lot of concern. The Attorney General said, I strongly disagree with the court's findings, and noted the concerns about private property. But if you have the fortitude and time to make your way through to paragraph 2086 of this decision,
Wow.
you will see the court noting that the government of British Columbia chose not to argue that issuing private property grants extinguished the fee simple, the Aboriginal title. They didn't argue it.
Yes.
And nor did the government of Canada. The government of Canada originally did and then amended its pleadings. And I think you can understand a bit about that if you look at civil litigation directives that both the provincial and federal governments have established that self-limit the arguments they will make in court. Self-limit them. We're not going to make these arguments and that argument. Now, I want to make this really clear. The concept of extinguishment of Aboriginal title is a very sensitive issue. And if
Yes.
a court were to find Aboriginal title extinguished in favor of private property owners, presumably there would be a live question about compensation to the Indigenous community, and perhaps vice versa. If the court said private property is going to be adversely affected, what remedies do those people have, having bought land thinking that the government said, here's good title? I looked in the land title, it says it's good. So the government chose not to argue those points because these directives promise not to. And, the Premier was the Attorney General when those were written. The Premier was the Attorney General for the first 3 of the 4 years of this trial. And, I think it's very important to understand that on this key issue, the court expressly noted the two governments didn't even argue it. The city of Richmond was left to argue this. And I mean, imagine you're the court and the city of Richmond saying, well, title was extinguished by the province. And then you look over at the province, we don't know, that's not our position. Puts a court in a very difficult spot, I think.
Well, I think it also spells out what's been going on too. As I say, that's why I think the appeal of this rings a little hollow to me. Of this decision by the NDP government, at least on a consistency basis. I'm not putting, I don't want to put words in your mouth, but and obviously this is so remarkably complicated, and as we alluded to earlier, how long it took to get through the courts, and to me, it just invites more problems. I mean, am I correct in saying that we had the Musqueam, Tawasin First Nations, sort of contested to some degree this case?
Oh, very much so. Very much so.
Yeah.
And they're not happy about it. And, with respect to whether the appeal rings hollow, I'll stay away from the political aspects of it, but I'll tell you this from a legal side of things. First of all, the judge doesn't get to defend herself. The judge doesn't get to come on
Mhm.
a podcast and say, this is
Yes,
what I
right,
was thinking
exactly.
as with you. So I think it's very important that anybody looking to criticize the judge realize the judge can only base a decision on what is argued. I'm not saying that I think I agree with all aspects of the decision, but I'm saying you have to be very
No, but
careful and
yeah.
respectful of criticizing judges who cannot defend themselves. And then the Attorney General saying, I strongly disagree with the opinion, and we've made arguments in relation to these issues, but she didn't specifically go to this point, which I think is a key issue. The other thing that I think is very important legally is when this goes to appeal, can Canada and British Columbia now even make this argument? Can they say, oops, we really
Mhm.
blew it? We think we need to
Yeah.
make this argument now? Is the court going to let them? Does it have a cloud over it? These are very important issues for the court.
And I'll come back, and again, it's not you, it's me saying a reminder that the BC Premier David Eby is well familiar with this file. He can't plead, ignorance of it. So again, there's going to be much more to this, though, Robin. Thank you so much for finding time for us, though. Your expertise is much appreciated.
You're welcome, Michael.